constitute work product in an investigation such as this. Notably, for example, I could send an email to Ms. Weeman, I could send an email to an officer saying, I'm coming by to pick up materials or documents. And so those sorts of routine correspondences are what's encompassed by the defense's request, and we would object as significantly being overly burdensome. There are a number of law enforcement agencies, officers in this case, and personnel working on this case. And so we are talking about thousands of emails, text messages that should be preserved. People already acknowledge their duty and burden to, or their duty to preserve other communications as it relates to the case, such as video recordings of the defendant or the witnesses.
I'm prepared to issue a written ruling on this order as soon as court is in recess later this morning. Both counsel are approaching this from their respective positions in good faith, but I agree with the prosecution that, for example, some language that was, quote, other memorialization of any and all people contacted regarding this case in any form or fashion, the court would find is overly broad, overly burdensome, and certainly in some form or fashion that may inappropriately tread on work product doctrine. So I'm going to issue an order with regards to the people's obligation under Rule 16 and limit any release of information that may tread on work product. Now, if counsel, either side, if the defense thinks that the prosecution is not complying with this court's order and is withholding particular statements or evidence, file a motion, request a forthwith hearing. If the people need some guidance on a particular communication or a particular issue with regards to this order that's going to issue in writing, file a motion. File a motion for an in-camera review of a particular recorded or otherwise documented statement. It's simply so broadly drafted, the court agrees we could end up in a position where we're litigating thousands and thousands of email or texts that may or may not be relevant to the investigation of this case. So I'll issue a written order that counsel will have today, and that'll be D1. And we had already ruled on D3 was previously granted, the motion for preservation of physical evidence. D2, there wasn't an accompanying order to the notice of representation and demand for notification of any non-testimonial ID procedure sought. The people acknowledge that, Ms. Reed?
Yes, sir.
If you're requesting an order be issued, Mr. Steigerwald?
Your Honor, if the court requires an order on that, it's customary for us to file some kind of notice, eventual appearance, and that's what that is.
So since there's no accompanying order being requested, it'll simply be made part of the court file and the people's acknowledgement there. So no order's going to issue. And next was, let's see. Make sure D3 was granted. D3 was already granted on December 21st. We're now on D4. By that I mean defense motion. I apologize, that's the one we just covered. D5, motion to limit pretrial publicity, Mr. Steigerwald?
That's a question. The court planned this. I think the people's response certainly stopped. To claim that there's not been an unusual amount of attention or we covered in this case, I think is can't stand behind that at this point. There's national media coverage, there's local media coverage. I'm not in this courtroom on a weekly basis, but I would imagine the amount of media in the room is not the normal for Teller County courts. We're not asking that the media be prohibited from being in the courtroom or anything like that. We're asking that the parties to this case not engage in press conferences, interviews, tweets, anything of that nature. And we're going to have a difficult enough time picking a jury to be able to get to that point in Teller County with the amount of attention that we've received already. And that's going to get more difficult if their media is getting information from one side or another and it's being spun. I don't believe it's not unusual for the district attorney to be getting phone calls from national news on Christmas morning. It's certainly unusual for me. So I think it's unusual. I think it would help both parties prepare for this case. Both for both sides to be represented properly. The media knows that there's not going to be comments forthcoming from the parties involved.
Ms. Freeman?
Your Honor, the people are fully aware of our obligations under the rules of professional conduct and how to interact with the media. I don't feel that a gag order is necessary for us to comply with the rules of professional conduct or to dictate for us to do. We will comply with the rules of professional conduct. I don't believe that a gag order is necessary.
I have reviewed and considered both the defense motion and the prosecution's response. I read every single case cited by the defense. None of them are on point, but they all point to what we all agree and is this court's obligation to ensure Mr. Frazie's due process rights are protected during the pendency of this case. I'd caution counsel to correct your cite in the Oaks case. It's 371 P. 2nd 443, not 433. You'll also want to correct your cite in the Smith case. It's 8 P. 920, not 8 P. 1045. Now, the code of rules are self-executing, and certainly the rules of professional conduct, sections 3.6, which address the prosecution's obligations, cover most, if not all of the requests made by defense. However, they are permitted, as the rule cites, to share some information without violating the rule. They're also obligated under 3.8 to exercise reasonable care to notify law enforcement, personnel, employees, and anyone else involved in a criminal case from making any extrajudicial statements that the prosecutor would otherwise be prohibited from making under Rule 3.6. And that's the very order I'm going to issue in this case, is that the prosecution comply with their Rule 3.6 obligation, inform law enforcement under 3.8. Again, if any matters come before the court that Mr. Steigerwald or the defense team believes have violated Rule 3.6 or 3.8, certainly the court can and will reconsider the motion regarding pretrial publicity. Yet at this point, the court does not find that a complete prohibition on making any statements is necessary to ensure Mr. Frazie's due process rights are protected. I'll issue a written order.
Sure, for your edification, we have told local law enforcement, the FBI and CBI, that all media matters from here on out should go through Lee Richards, our PIO. She's also been in contact with law enforcement out in Idaho, because we saw an article that came out of there, and again, asked them to all go through Lee Richards, and we have told them that they should not be putting out information at all, and everything will go through our office, and we intend to comply with 3.6 and 3.8, and that you want to know what we've done in regards to asking law enforcement not to communicate except through the DA's office.
Thank you, Mr. May. I appreciate that record. You'll also see in my written order, and what I've instructed my staff is that my staff cannot make any comments, and in order to at least minimize any question about that, only my clerk of court, Sheila Griffin, and my staff in the Division 11 chambers, and Judge Sell's staff, when he assumes this position in January, are going to be releasing or doing any document control in this case. But all of our document release and all media contact is going to go through the state Judicial Department Public Information Officers, John Sarce, who's here today, and Rob McCallum. So from the media's perspective, do not come to the court clerk's desk and ask to have documents released to you. All of our information, all of my court orders are available and will be released through the PIO as part of our public record. But we just don't have the staff in this small rural district to ask that they constantly be responding to those requests, that the information that is available will be made available through state judicial. That covers, I believe, Council, correct me if I'm wrong, the motions that came in between December 21st, but now I'm seeing a motion filed by the prosecution this morning. Was there anything else, Mr. Steigerwald, on those other pretrial motions before I turn to the people's motion for consumptive testing?
No, Your Honor. I would ask we not address that motion today.
And I spoke with Judge Sells about that, and obviously, it just having been filed, when I was doing my docket prep again this weekend, I hadn't seen that yet, so I haven't had a chance to review it. Do you want that calendared for a hearing? You're entitled to a hearing. The prosecution has complied with giving you reasonable notice, but I'm not going to sign an order today without the defense having an opportunity to respond. Counsel? I don't know what the timing involved is, as indicated in your motion. CBI indicated to you there may be some consumptive testing. I just don't know what the timing is involved, Ms. Beeman.
I'm not sure how to answer that question. All I can say is that the item that's discussed in that motion, it was relayed to me through CBI that it would be, the testing would be consumptive of that particular item. I have been in contact with CBI in terms of the procedures that they follow when it comes to consumptive testing. They've provided me their protocols for me to provide to defense. The general protocols are that defense has someone to observe that testing.
Right.
And that would be done at the Pueblo lab. So in terms of timing, I would want that to be completed as quickly as possible. So if we could address that motion sooner rather than later.
Mr. Steigerwald?
I don't have any problem with addressing it sooner rather than later. To be fair, I think I filed late Friday. I saw it over the weekend.
No.
That was a late Friday motion, but there's simply, seeing late Friday, there's not time for me to figure out if there's
Sure.
we need to hire an expert to be present or an investigator is sufficient. The people still have not turned over the probable cause affidavit.
We'll talk about that.
So I don't have any information as to what this is. So it's hard for me to kind of determine what I need present.
The motion may have gone into clerk review, which I can't access, just in our electronic filing system. So do you want this calendared on the afternoon of the 7th?
Just for the trial, that's what kind of something that's all cases willing to go. We're going to be setting a preliminary hearing.
Right.
I would like to address it before a preliminary hearing.
The 14th?
It's a 2-week, pretty intensive trial.
Could Ms. Porter handle, well, sorry, I'm digging out our calendar. We only have criminal docket days on Mondays.
Would it be possible for us to handle this maybe even this Friday?
Could you handle it this Friday? Do we have a court reporter available Friday?
Sure.
What time is counsel available?
I'm available, of course.
The afternoon is easier, but I can get coverage for the morning. Appearance if the court only has the morning available.
I'm sorry, I didn't catch that?
If the court is only available in the morning. I
Oh,
can be
no,
available.
I'll make myself available anytime. Friday the 4th at 1:30? Will that work?
Yes, ma'am.
We're gonna have to be in the county courtroom that day. Friday is the reworking of our computer system here in this courtroom. So we'll see you in the county courtroom on Friday the 4th at 1:30. As far as calendaring preliminary hearing, did you want to combine that with a proof evident presumption great hearing as well?
Yes, ma'am. We request that from 35 days.
How long does council anticipate needing, Ms. Beeman, Ms. Reed? Okay. Let's see. What do you see, Nancy? Do you think? Well, we can't. We're gonna have to do it off docket to give them a day. I'm just trying to find any day. They want a day. What the 22nd? Oh, that's jury. If we put it on that civil week, the 29th? We'll have to reset that.
January 29th.
Well, it's okay. January 29th at 9 a.m.
That's fine. Huh?
Does that work for the people?
It does.
Will you contact council on the 9 a.m. They've already been bumped once by this case. If we could move them, if we move there, it's a contempt advisement. If we move them to 8:30, otherwise we'll have to move them to another date. But I don't want to double set them against this hearing. All right. Now I'm sure Mr. Steigerwald has an ability to prepare with everything still under seal. Ms. Beeman, I don't know what the status of your investigation is. There were some ongoing searches which resulted in this court granting the request to rescind the prior agreement about releasing the arrest warrant affidavit to defense counsel.
Your Honor, my request is that we release the probable cause affidavit to defense counsel under protective order, that defense counsel is not to disseminate that to anyone, including the defendant at this point, until we've had a communication with defense counsel about that issue. Because the issue is there's still an ongoing investigation and multiple investigative leads and different things that are being followed up on. So at this point, I would agree I will release it to defense counsel. And then also there will be discovery that's going to be released to defense through the normal course of discovery that he will obtain. But at this point, I will release the PC affidavit to defense under that protective order.
Today?
I can release that to defense today, and I would just ask for that protective order to the defendant himself for a week.
Mean that counsel not even be permitted to discuss it with his client or show it?
For a week,
Not discuss it?
yes.
Mr. Steigerwald?
We've been asking for the PC update or protection order for 10 days. The people had agreed to it, obviously, initially, and then changed their minds. I don't think the court or the prosecution can prohibit defense counsel from discussing a case or evidence with the client. If people are asking for an unconstitutional restriction on the right to represent Mr. Frazee.
We're only asking for a week, Your Honor, given the multiple needs and the multiple investigation issues that are prevalent throughout this case. I'm only asking for 1 week.
Now, Mr. Frazee is being held without bond. His phone calls are being recorded. His visits are being monitored.
If we want to litigate this, I want some authority from the prosecution. I think we've got a direct tension with the Sixth Amendment, or the constitutional right to be represented by counsel. How is counsel to even start representing his client and preparing if he can't even discuss the information he's receiving? So I'm happy to consider it. We can address it again this Friday. File your authority at least the day before, and Mr. Steigerwald, you as well, please. I'm well aware there are multiple investigations going on in multiple states, and the prosecution does have the right to ensure that that is not hampered, yet Mr. Steigerwald has the right to, and Mr. Frazee has the right to be represented by counsel who can effectively represent him. So we're going to address that motion as well on the 4th at 1:30. All right. Anything else? Anything else?
Your Honor, I would just ask that the motion for consumptive testing be sealed at this point.
It will be suppressed. That way, technically, Mr. Steigerwald in defense has access to it. If I seal it, then he doesn't even have access to it. Any objection to that?
No.
All right, so it'll be suppressed. That motion is not available to the public until the court addresses that order, unless there's a defense objection you want to address, Mr. Steigerwald?
There's not those.
All right. Can you put that under motion and order suppressed, please? All right. Anything else?
No, Your Honor.
Right, we're in recess. And Mr. Sarce, you'll help media get everything. You can just come collect your equipment. Don't mind me. I'm just going to stay on the bench. We're going to just keep working and starting the rest of our docket. And deputies, when you can get Mr. Frazee removed and secured, you can bring up our next in custodies, please. Huh? Yeah. And we'll do a CNR transport order for Friday at 1:30. Thank you.